Can you elaborate a little bit on the confirmation process? What you do to prepare before you're sworn in?
Sure, you're interviewed by the Senate Judiciary Committee, and they ask you a bunch of questions, and um, you know, I knew all of the senators because I'd been working in the State House every day for 3 years. The only issue about my confirmation was there was nobody on the Supreme Court at that time from the southern part of the state. So, if I remember correctly, one or two senators from the southern part of the state objected. And they said the governor should appoint somebody from the southern part of the state. It was not meant personally as an objection to me. It was simply a regional objection, if you will, by a couple of guys who thought it was time that South Jersey should be represented. Of course, South Jersey is well represented today with Justices Solomon and Justice Fernandez Vina. But at the time, there was nobody from south of Flemington, which is where Justice Handler lived. So that was the only issue. You know, they asked me what my judicial philosophy was, and to tell you the truth, I'm not sure I knew what it was because I had never been a judge, and so it really required a little time on the bench for me to acquire a judicial philosophy. But I answered the questions as best I could, and confirmation was not a big problem.
So again, having not been a judge prior to this, and suddenly being on the highest court in the state, how do you prepare yourself personally for that?
Well, a lot of people have asked whether or not you need to be a judge first, and I've always believed that you don't. And in fact, the tradition in our state, going back to other governors, I think Chief Justice Weintraub did serve a little term on the trial court before he was elevated. Certainly, Chief Justice Vanderbilt did not. He was the first Chief Justice and was taken by Governor Driscoll right from private practice, as were many other justices on the court that I joined. Justice Handler had been a judge before. Justice Pollock had not. Justice O'Hearn had not. Justice Clifford had not. Justice Garibaldi had not. And Chief Justice Wilentz had not. So it was not uncommon for governors, Justices Handler, Pollock, and O'Hearn all had served as counsel to Governor Byrne. It was not uncommon for governors to look to their circle of close advisors to pick justices because they were people that the governors knew well and trusted and believed that they had both the intellectual and governmental experience to serve on the court. And my own perspective is that I think the experience I had in the governor's office was more important than service as a trial judge. The roles are different. The Supreme Court, of course, as you know, doesn't try cases. We hear appeals from decisions by the appellate division, which in turn hears appeals from trial courts. So the questions we confront are issues of law. The experience of a trial judge often is dominated by the day-to-day tasks of picking a jury and ruling on challenges to jurors, presiding over trials, which requires trial judges to have a more intimate knowledge of evidence law, because in the course of a trial, a lawyer will offer evidence there'll be objections. The judge has to rule on the admissibility of evidence, on limitations that apply to different items of evidence. Judge has to rule on motion practice. So the discipline of a trial judge is significantly different. And so I believe that the role of a justice on a state Supreme Court or even on the federal Supreme Court is a role that can be filled by somebody with significant law practice experience, somebody that has a scholarly bent for the law as well as practical experience. But I don't believe it's necessary to be a trial judge. And perhaps the best example would be Earl Warren, who was President Eisenhower's designation for Chief Justice. Earl Warren had been the Attorney General of California, the Governor of California, never served as a judge, and of course presided over the famous Warren Court. He was the Chief Justice that managed to get a unanimous court for Brown against Board of Education. And there are many other examples in our history of extraordinary justices. Justice Douglas comes to mind. Justice Black comes to mind. Justice Frankfurter comes to mind. And many others who were chosen for service on the nation's highest court without ever serving as a trial judge. Mm-hmm. So I thought when I finally got my sea legs under me and began to feel comfortable on the court that I had been better prepared for that job by my service as an advisor to Governor Kane than I would have been had I been a trial judge.
Mm-hmm. So, the Chief Justice when you joined was Robert Wilentz?
Yes.
Yeah. How did kind of take us through your first experiences as a member of the court?
Well, the day the governor announced my nomination, Chief Justice Wilentz called me. I think there was some kind of meeting of the judiciary, and he invited me up to meet everybody, and that was a little bit awkward because there were all these judges, many of whom didn't know me, some did, but who's this guy all of a sudden is brought into our midst as the next justice. But when I got there, the court was very welcoming. I had heard from everybody in advance. I had sat in on a couple of conferences just to get the hang of it and see how they did things. When I guess attended my first conference, maybe before I was sworn in, Justice Handler said that he had shared a sandwich for lunch with Justice Schreiber for many years. And he said, "How would you feel about sharing a sandwich with me?" Of course, I had been able to eat a whole sandwich for most of my life, but I didn't want to appear to be rude or to appear like I was an overeater, so I said, "Sure, I'll share." "What kind of sandwich do you like?" "Well, tuna fish is good." So for the next 15 years, I split a tuna fish and tomato sandwich with Justice Handler. Did we ever branch out? Maybe we got a turkey sandwich sometime. But it was funny because when Justice Coleman joined the court, he put his foot down and said, "No, I need a whole sandwich. I get hungry." But, they explained to me what the process was, and it was daunting. The first set of oral arguments that I sat in as a justice were the first set of death penalty cases, Biegenwald and Ramseur. And the way you would prepare for oral argument is that the clerk of the court would send to your chambers the briefs. And of course, the death penalty was so controversial, it had attracted not only the briefs for the state and from defense counsel, but the briefs of many amicus, friends of the court, who are arguing that the death penalty was unconstitutional. In addition to which, every case that we have argued before the court has the benefit of a bench memo prepared by one clerk, and that bench memo prepared by that clerk goes to all the justices. So you have the briefs and the bench memo, and you have the trial court record, which in the death penalty cases was voluminous because the trial record. And so I remember being flabbergasted by the volume of material. And beginning with my first set of oral arguments and continuing until my last, I probably worked not only every day, most nights, and every weekend for all of the 17 and a half years I was a justice. It is an enormous amount of work just to stay even. Just to stay even. You have to prepare for oral argument, and so what good does it do you if 10 days before an oral argument you read all the briefs and the bench memo, and then come to oral argument 10 days later and forget what you read? So almost all of us would dictate memos to ourselves to summarize what we read so that the day before the argument you could go back and read your own memo and recall what conclusions you'd reached in preparation for the oral argument. And it was a very challenging group of people to be seated among. Chief Justice Wilentz was a man of dazzling brilliance, extremely quick, a wonderful wit, and of course he had grown up in a very sophisticated, in very sophisticated circumstances, because his father, David Wilentz, had been the state's attorney general, had been the prosecutor of the Lindbergh baby kidnapping, and was a political powerhouse, the Democratic chair of Middlesex County, and a political leader in the state. Justice Clifford was one of the state's best trial lawyers, done defense work for years. He was Governor Cahill's commissioner of corrections and institutions and agencies, and one of the quickest witted lawyers I've ever met. Justice Pollock had been on the Public Utilities Commission, had been counsel to Governor Byrne. Justice O'Hearn had been the mayor of Red Bank, counsel to Governor Byrne. Justice Handler had been an appellate division and a trial court judge and a deputy attorney general who had argued some of the state's most important cases, including before the United States Supreme Court. And Justice Garibaldi was a legend in her own right because she was the first woman chair of the state bar. So it was a very impressive group. I was the junior justice, which meant that whenever there was a knock on the door, I got up and opened the door, and I took the conference notes for 11 years because I was the junior justice for 10 or 11 years, however long it was, between my arrival on the court and the time that Chief Justice Wilentz passed away. But it was a wonderful group of colleagues. I mean, it was absolutely a delight to have served with that particular bench. I went on to serve with other wonderful justices afterwards, and I was, I guess, the last survivor of the Wilentz Court, so to speak, in terms of leaving the court.
Mm-hmm.
But the 10 or so year run that we had with the 7 of us was extremely special. We were a very cohesive court. We got along well. We respected each other's views. We agreed very often. Sometimes we disagreed. But it was a court where there was never a personal, there was never an unkind comment that had a personal sting to it. We were a totally collegial court. It was just an absolute delight to have served with that group.
I want to ask about some of the cases, but first, I wanted to ask, where do you think that collegiality comes from? Is it just sort of a tone set by the chief, or is it?
I think that the Chief Justice has a great deal to do with it, and Robert Wilentz was good at that because he could be extremely funny, very, very funny man. He could do imitations. He would often have a very light touch to the conferences. And the conferences were tough days. We'd get there at 9 o'clock and leave at 6.
Mm-hmm.
And we would spend the day debating cases and disagreeing with each other. So I think he had a lot to do with it, but I think it was simply the mix of personalities and individuals on that court that made it as cordial as it was. Justice Clifford was hilarious. Before every conference, he would put up an easel, draw a line down the middle, and on one side put plus, and on the other side put minus. And during the course of the conference, he would editorialize by putting some comment you'd made in either column. If you said something that even bordered on being out of line, it would wind up in the negative column. And it was just a lot of funny things went on during the conference to make the day lighter, because it wasn't a light day. You know, we would start with deciding the cases, and I'll tell you how that worked. But it was just a very intense day of discussion about substantive issues by 7 people that liked each other but didn't always agree. And that was a phenomenon. I mean, Justices O'Hearn and Justice Clifford particularly were close friends, and we agreed much more than we disagreed. But there were days when we didn't agree. And it was fascinating because we all came to the court from different backgrounds, and so we could look at the same set of facts, the same trial record, the same briefs, and reach opposite conclusions about how the law ought to resolve the disputes in the case. And so sometimes you found yourself, as I did often, probably more often than anybody else on the court, as a lone dissenter. And sometimes you were part of a unanimous court, and you almost never knew until you went around the table to see how everyone voted.